Hello, everyone. It is with great pleasure that I welcome you to today's roundtable discussion in the context of Foundations of Human Rights module. In particular, I would like to welcome our guest speaker, Mr. Jacob Mchangama, founder and executive director of Justicia, who will be delivering a roundtable discussion entitled, "Does the ECHR really protect the right to offend, shock, or disturb? A critical assessment of the European Court of Human Rights hate speech case law." Now, as the module leader of the Human Rights module, I would like to say that our students have really been looking forward to today's discussion. Freedom of expression has been one of the most interesting yet controversial areas of human rights that we have to deal with so far. We have had some really interesting discussions in class, and students were really eager about today's roundtable, especially when it comes to the very meaning of hate speech and the scope of permissible interferences with freedom of expression in that respect. So now I will leave the virtual floor to Stéphanie, our head of school, to welcome our guest speaker and provide some more information about today's event.
Thank you, Demetra. Thank you for having us into your class, and thank you to the students for having us. But also we have a number of external guests here, so welcome to everyone, and particularly our guests from Justicia, Jacob and Natalie. But let me say a few more words, both on behalf of the law school of UCLan Cyprus, but also on behalf of the EU POP team, which is basically the European program that is hosting this event today. So, of course, it's a real pleasure and honor to have you here. And it is even more important for us to be able to reflect together on a fundamental societal issue, which we can say truly is of global dimension. It is as much of global dimension that it is of local dimension. So hate speech is something that crosses apart, and it's something that we are very interested in. But particularly, as Demetra said, looking at the comparative notion of hate speech. I had a look at Jacob's slides in advance, and I'm happy with that very interesting comparison of the various sources of interpretation of what is hate speech and combating of hate speech by the European Court of Human Rights. But combating is something that we need to analyze. So let me warmly welcome Jacob Mchangama and introduce him. Thank him for his willingness to be with us today, because I know he's very busy and he has given time away to be with us here in Cyprus, and also for his enthusiasm. I have watched a few videos on YouTube, which Natalie kindly forwarded to me, and I'm most impressed. So thank you for being with us. Obviously here it's a mixture of many institutions that we are very proud to work with. So it's of course our host organization, which is Justicia, but it's also the School of Law, its LLB and its LLM students, and it's also the Jean Monnet module EU POP. So we are lucky that in this roundtable we have a variety of participants composed of lawyers, academics, experts at international organizations, and students. So we have a very good mix of people to be able to discuss. Before I continue, I need to remind you that this roundtable is recorded for the purpose of widening access to educational resources, such as this roundtable, and that you have been asked to consent to this. So please, participants, keep your cameras off as much as you can, and of course your micros off. And you can use the chat function in the MS Teams classroom. If at the later point of the roundtable you wish to actually switch on your camera and switch on your micro, we will give you that opportunity as well. But you have to know that this is recorded. So can I please also remind you that each of the speaker and the participants who will actually speak today will do this in an educational capacity. So in other words, for educational purposes, in an educational setting. That means that each participant, whatever they will say, verbally, electronically, or otherwise cannot be accepted or interpreted either as legal advice or advice of any sort. You may view the materials on the MS Teams. You may download the materials as well. For example, the slides that Jacob very kindly provided us with. But please make sure that you provide the necessary acknowledgements if you use those materials. So let me just say a few words about Jacob's impressive bio and CV. Jacob is the founder and executive director of Justicia and a visiting fellow at the Foundation for Individual Rights in Education in Washington. He's the executive director of the Future of Free Speech project, which is being introduced today to us. In 2018, he was a visiting scholar at Columbia's Global Freedom of Expression Center written the American way, I noticed. He has commented extensively on free speech and human rights in outlets including the Washington Post, the Wall Street Journal, The Economist, Foreign Affairs or Foreign Policy, so in other words, magazines. Jacob has published in academic and peer-reviewed journals, including the Human Rights Quarterly, Policy Review, and Amnesty International Strategic Studies. Jacob is the host and narrator of a podcast series that is called Clear and Present Danger, a History of Free Speech, and is the recipient of numerous awards for his work on free speech and human rights. I encourage everyone to look at the podcast series. Jacob's book, Free Speech, A History from Socrates to Social Media, which is a provisional title, will be published by Basic Books US and Basic Books UK in 2022. Let me say a few words about Justicia and then about the project. So Justicia is a think tank that was founded in August 2014 in Denmark, and it is Denmark's first judicial think tank. It aims to promote the rule of law and fundamental human rights and freedom rights, both within Denmark and abroad, by educating and influencing policy experts, decision makers, and the public. And this is why Justicia is with us today. In so doing, Justicia offers legal insights and analysis on a range of contemporary issues, such as hate speech. Now, the project which is being presented to us today, is the Future of Free Speech project, which is a very, very fascinating project. It is a collaboration between the Copenhagen-based judicial think tank Justicia, Columbia University's Global Freedom and Expression Center, I suppose, and Aarhus University's Department of Political Science. So by itself, this is a very interesting transatlantic collaboration. And the idea is to understand better and counter the decline of free speech. The Future of Free Speech project tackles three big questions. Why is freedom of speech in global decline, first of all? How can we better understand and conceptualize the benefits and harms of free speech, secondly? And thirdly, how can we create a resilient global culture of free speech that benefits everyone? So these are fascinating questions that obviously have many, many different ramifications and dimensions. Thank you very much for listening to me. I give the floor to Andrea Manoli, who is an EU POP Research Fellow. Andrea will introduce the Jean Monnet module EU POP. Thank you.
Hello all, and thank you for being here with us today. Thank you, Jacob, for accepting our invitation. I will provide a project summary. As Stéphanie said, so the EU is faced with a threat to its very foundations through the rise of right-wing populist narratives and political parties, and in the form of inter alia Hungary and Poland. The current climate of uncertainty, migration flows without adequate integration policies in many European countries, including Cyprus, and the rise of fake news, particularly online, constitutes a fertile setting for the rise of right-wing populism. So the climate generated by such phenomena are damaging in themselves and also in their manifestation, such as in relation to the protection of the rule of law and human rights. So the proposed module is established on research-informed teaching of the soft and hard tools available at an EU level to challenge the right-wing populist threat and its manifestation in the form of deterioration of the rule of law or risk thereto, hate speech, including online hate speech, hate crime, aggressive Euroscepticism, currently tainting Europe at a local, national, and regional level. To this end, the module entitled European Union Law and Governance in Populist Times was developed on the premise that there exists an urgent need to develop research in the area which continues to remain underdeveloped, enhance teaching excellence in the field so as to ensure that young professionals and graduates are well equipped with the ability to understand the regulatory framework in the EU, and to foster coherent dialogue between stakeholders, civil society and academics on the chosen theme, and finally to offer a core output to the Commission on guidelines for improving of the current regulatory framework. During the project, we will host 3 experts at UCLIN Cyprus. We hosted Dr. Ulat Belavusau from Asser Institute and the University of Amsterdam last year. On the 31st of March, we will host Mr. Andreas Marcou, who will speak on the European Parliament actions in tackling populism. And next year, we will host Professor Dimitri Kochnov from the University of Groningen. So the knowledge and skills developed by the teaching team and the general expertise developed in the framework of the project culminated the development and publication of the first peer-review journal on populism. Furthermore, intensive summer schools will run throughout the lifetime of the project, which is open not only to students, but also stakeholders, policymakers, and the wider public. I remember that some of you have participated in our first summer school. Also, an open educational platform of information on the project and all the outputs of the project, such as a recording of guest lectures, videos, guidelines, a link to the online journal, and the working paper series was created. The working paper series will allow students who are benefiting from the module to be able to publish their research. The platform aims at bringing together the material and outputs of the project, which will also raise visibility of the Jean Monnet program. And during the first trimester of the project, a digitalized bibliography was prepared, aiming at enhancing awareness on available literature on populism and the law, with a particular focus on the EU. The module also issues newsletters, 4 of which have been already published and can be found in social media as well.
Okay, thank you very much, Andrea. So now let me turn to Andreas Marcou, who is also an EU Pop Research Fellow. And basically, Andreas will introduce as much as you can, because it seems to be a difficult topic, your views on today's roundtable's topic. Thank you, Andreas.
Hi, thank you very much, Stephanie. Thanks, Jacob, for being here today. I know that everyone is looking forward to hearing Jacob talk, so I'm going to keep my comments rather brief. What I'll try to do is essentially draw some links between populism, hate speech, and free speech, and essentially tease out some of the questions that will probably motivate much of what Jacob has to say today. I know that many people are not familiar with populism, so I'll start with a very brief a description of what populism is, what it entails, and what the problems associated with populism might be. Populism is essentially a kind of discourse, a kind of way of talking about politics, and it entails the distinction of the society between the ordinary people and the elite. This distinction is moralized, meaning that the people, the ordinary people, are seen as virtuous, uncorrupted, noble, and they stand against some corrupt elite who are looking to undermine and exploit the people. Very often, a populist discourse is combined with different ideologies. Andrea mentioned that the focus of the Jean Monnet module is on right-wing populism, and right-wing populism typically combines populist discourses with nationalist ideologies. And the idea here is that the ordinary people possess and they represent some sort of national identity, which must remain pure and uncorrupted. And those who threaten that identity are the subject of criticism and occasionally of attacks. Unsurprisingly, this rhetoric, this sort of talking about parts of society, gives rise to instances of hate speech. Hate speech would be widely employed within such a populist regime as a way to target those who endanger the national purity. Whereas members of the people, of the demos, represent what is good, foreigners, refugees, or asylum seekers are portrayed as a threat to national identity, and therefore hate speech is directed against them. Of course, depending on the specific circumstances within which populism rises, those targets might also include religious minorities, sexual minorities, or essentially anyone who is different enough to undermine national purity. Now, given the ways in which hate speech typically targets vulnerable groups, we might wonder why legal systems don't enact relevant legislation to protect those vulnerable groups. And it is true that blocking hate speech could be a way to protect vulnerable minorities and ensuring that hate crime, which is often the result of such hate speech, is prevented. But of course, there are very powerful considerations against imposing such legal limits. Democracy very often emerges as the answer to questions of legal and political legitimacy. And democracy comes with certain features, certain characteristics. Some such features, such as freedom of speech, essentially they constitute democracy. They are democracy. And if democracy is this kind of a legal system that promises participants the freedom to speak their minds and expressing one's viewpoint within public discourse becomes democracy, right? It becomes the definition of democracy. To speak freely, therefore, would also entail a right to offend, disturb, or cause distress, which rights Jacob will, of course, discuss in much greater detail in his speech. So limiting speech because it might cause others offense would essentially undermine democracy, at least to some extent. Perhaps more worryingly, limiting speech because it might cause offense has historically been used as an instrument to stifle dissent and maintain a strong grip on power. So the question becomes, where does that lead us with respect to populist regimes? Well, within populist regimes, we've seen that hate speech becomes a device to target and attack vulnerable minorities, right? Seeking to ensure this sort of national purity, gay people, foreigners or refugees, or anyone else who is deemed different will be subject to slurs, verbal attacks, and potentially even harassment. Of course, those same populist regimes would invoke limits to free speech in the name of public order, decency, or religion. They would invoke free speech in allowing for speech to target minorities, but on the other hand, they would happily restrict speech that might emerge as dissent or protest, alleging that it might be too offensive or distressful for the communal feelings. It appears, therefore, that populist regimes who crucially have a very difficult relationship with democracy, right? Very often those populist regimes emerge as undemocratic or challenging democracy. They act in ways that could, they view essentially free speech in instrumental terms, right? Whatever will help them manage their agenda. So it appears that the question to regulate speech or how to regulate speech or to designate some speech as beyond the scope of legal protection is one that goes to the heart of the democracy debate. How can we make sure that free speech as a democratic guarantee is safeguarded while asserting that some specific kinds of speech maybe they ought to be proscribed? And how do courts, as the principal bodies of a legal system, protect the right to offend, shock, or disturb, given the possible concerns raised by hate speech? Today's roundtable, in my view, constitutes one attempt to not only investigate the limits of free speech and the dangers of hate speech, but also to look more particularly at how courts, such as the European Court of Human Rights, approach such essential questions. Once again, thanks, Jacob, for being here, and we really look forward to hearing your thoughts on the topic. Thank you.
Thank you, Andreas. Very interesting. Thank you very much. Jacob, we are listening to you. Thank you so much.
Well, thank you so much for this invitation. I really look forward to this interesting roundtable. I'm deeply sorry that I can't be there in person. I would have loved to be in Cyprus right now. I've actually never been, which is a regret. But I have been optimistic enough to book tickets in October to your beautiful island. So hopefully I'll get to enjoy the atmosphere then. Today's topic, as was eloquently just set out, is one that is really pertinent to our time, not least since we live in a digital age where for the first time in human history we have approached something like, at least theoretically, free and egalitarian speech, where in principle every human being with an internet connection has the opportunity to access and share information globally in real time. Now this on one hand is of course a huge boon to the ideal of free speech and the very egalitarian ideal of free speech, which in my opinion was what gave rise to it in the Athenian democracy, although not on a global scale back then. But on the other hand, the egalitarian free speech model of social media also means that all types of movements and ideas that were previously only rarely made it to the surface and now can get out there and can even be leveraged due to algorithmic distribution. And this, of course, has caused a lot of concern, not least because we have seen how organized campaigns of incitement against various groups have contributed to, for instance, crimes against humanity in places like Myanmar and Sri Lanka. And of course, in every single instance of genocide or crimes against humanity, organized propaganda aimed by the in-group against the out-group is a necessary precondition, whether it's radio as in Rwanda or today social media in Myanmar. So that has heightened the attention for good reasons on what to do about hate speech. And here, international human rights law has a potential role to play, because even though much of modern discourse takes place on privately owned platforms, international human rights law has a potential to serve as sort of a benchmark against which these platforms should do their content moderation, since they and increasingly not states are the ones who are the first line against various types of speech that we don't like. But at a global level, this becomes very, very tricky, because, as was alluded to, there's no agreed definition on what constitutes hate speech. And it depends also very much upon values, plus it's a concept that can be easily abused. And as I hope to show, even within the relatively homogeneous, at least from a global perspective, Europe, operationalizing a definition of hate speech has been difficult. And I will argue that the European Court of Human Rights, who draws the ultimate red line, has not been able to really conceptualize this concept in a convincing manner. But I don't want to start with the issue of social media. I actually want to go back, because I think this is really important for understanding the context that gave rise to international human rights law and the question of hate speech. I want to go back to 1937, where European fascism was on the rise. You had the Third Reich, you had Mussolini in Italy, and so on. And here you had the German professor Karl Löwenstein, who was an immigrant of Nazi Germany, who coined the term militant democracy. So Löwenstein warned that the lack of militancy of the Weimar Republic against subversive movements stand out in the post-war predicament of democracy, both as an illustration as a warning. And in particular, Löwenstein accused democracies faced by fascist movements of having gravely sinned by their leniency or by too legalistic concepts of the freedom of public opinion. In a similar vein, the famous Austrian political philosopher Karl Popper developed the so-called paradox of tolerance in his The Open Society and Its Enemies, which he wrote in 1945 in New Zealand while he was in exile from the Nazi regime. So according to Popper, the very survival of tolerance required defenders of tolerance, of liberal democracy, basically, to be willing to fight the intolerant with intolerance. In the other corner, we find George Orwell, the British author who fought communism with his pen and fascism with weapons during the Spanish Civil War. Now, unlike Löwenstein and Popper, Orwell cautioned against the widespread tendency to argue that one can only defend democracy by totalitarian methods. If you encourage totalitarian methods, the time may come when they will be used against you instead of for you. Now, these divergent views on the proper role of free speech, the proper role and limits of free speech in democracies, were also prevalent when international and regional human rights conventions were being erected on the ruins of post-World War II Europe. You're all familiar with Article 10 of the European Convention on Human Rights, I take it, where you have paragraph 1, which sets out the right, and then you have paragraph 2, which sets out a number of permissible restrictions to Article 10. But what is interesting is to look a little bit into the drafting history of Article 10, as well as the ICCPR, and actually also the Universal Declaration of Human Rights. Because even though if you look at Article 10, there's no duty to prohibit hate speech, unlike what you find in Article 20, paragraph 2 of the ICCPR at the UN level. You do have Article 17 of the European Convention, which is the non-abuse clause, and which is interpreted a little bit like Article 20. But there are actually specific reasons why the European Convention does not include a specific duty to prohibit hate speech, unlike the ICCPR, because there were proposals during the drafting period to adopt something like Article 20. Turkey adopted had a proposal which was based on its own law on the spread on prohibiting the spread of extremist propaganda, but that was rejected on the grounds that it was too expensive. And Greece, it's funny, I guess, that it was Greece and Turkey, but Greece also proposed similar measures that were rejected since they were said to be covered by Article 17. But if we go to the UN, the conflicts over where the limits on hate speech should be drawn actually were roughly divided along Cold War lines. So back when the Universal Declaration was adopted, the Soviet Union was the main proponent of including a duty to prohibit hate speech, and they did so by basically verbatim taking submitting a proposal which was based on Article 123 of the Soviet Constitution of 1936. Eleanor Roosevelt, who was the chair of the Commission on Human Rights, emerged as a very principled, hard-nosed opponent of these attempts and as a very principled defender of free speech. And interestingly, when Article 20, paragraph 2 of the ICCPR was put to a vote, not a single member of the Council of Europe states at the time voted in favor of its adoption. And why did they not do so? Well, they were afraid that incorporating a duty to prohibit hate speech would be a dangerous development under human rights law. So the Norwegian representative who spoke on behalf of the Scandinavian countries said that advocacy to national hatred that constitutes incitement to hostility was so easy to misconstrue that those whom the provision was supposedly designed to protect might very well find themselves its victim. And I will argue that this was a bit of a prophetic statement, not necessarily so much within the Council of Europe, but very much so at the global level, as I will get back to. But we do have Article 17 of the ECHR, which I mentioned, the non-abuse clause, which was modeled on which basically had as its underlying purpose that it was supposed to hinder the growth of nascent Nazi, fascist, or other totalitarian ideologies. So on the one hand, you have the European Convention with Article 10, which allows a number of restrictions, and then you have Article 17, which I would argue was primarily there to counter totalitarian movements that proved a specific danger to member states. But there was not, when this was drafted, I don't see any evidence that member states were basically trying to adopt hate speech or to defend hate speech laws in the shape that we know them now. But nevertheless, a substantial amount of the European Court's contemporary case law restricts free speech when such speech is, for instance, insulting towards groups defined by certain characteristics. So arguably, even though the court's well-known dynamic interpretation has strengthened many of the convention rights compared to their original scope, it has arguably weakened the protection of freedom of expression when it comes to hate speech, even though the court, as I shall get back to, has not properly defined this. Of course, in many other ways, the European Court has strengthened freedom of expression, freedom of, when it comes to freedom of the media, defamation, and so on. But in this specific instance, I would argue that the court has restricted the scope of the right. And this might seem ironic when we look at the Handyside case, or at least this well-known paragraph from the Handyside case which insists that freedom of expression includes even protects ideas that offend, shock, or disturb. But when we look, and this is something we've done at Justitia, not least through the excellent work of Natalie, who's also here today, and we've done a substantive assessment of 60 identified cases that we label as hate speech and were decided between 1979 and 2020 within the scope of the European Convention on Human Rights. 57 of those cases were brought by the utterers of speech and 3 by targets. And our analysis reveals that 61% of the cases brought by the utterers resulted in the applicant's loss, through a finding of a non-violation or even being manifestly ill-founded. So only 39% of the cases brought by the utterers or speakers have resulted in a finding in favor of the applicant. So on average, free speech restrictions in cases that we label as hate speech have been upheld in just over 1 out of 3 hate speech cases. And this, I would argue, shows is a hint, at least, of the relatively low threshold that required for member states to restrict hate speech. But I will also hope to show that there's a lack of conceptual clarity in how the European Court of Human Rights views and deals with hate speech cases. There is, as I mentioned, no universally accepted definition of hate speech, although, of course, you can find various attempts in both in the national criminal laws of member states of the Council of Europe. You can find you have, as I mentioned, Article 20 ICC PR. You have the EU framework decision on racism and xenophobia, and so on. But the European Court itself has mentioned the term hate speech in 21 out of the 60 examined cases that we identified in our study. And the first case was the Zurich versus Turkey from 1999. But we still don't have that substantial, refined definition of hate speech. One attempt comes in the Gündüz case from 2004, where the court says that there can be no doubt that concrete expressions constituting hate speech, which may be insulting to particular individuals or groups, are not protected by Article 10 of the Convention. And perhaps the most, the closest step that the court has taken to conceptualize hate speech is in the recent Viljandal versus Iceland from 2020, which deals with homophobic comments made under an online article by a senior citizen regarding a proposal to strengthen education and counseling in schools on matters concerning those who identified themselves as members of the LGBT community. Now, this particular individual wrote under this article, "This is disgusting, to indoctrinate children with how sexual deviance," his words, "copulate," his words, "in bed, how disgusting." And here the court set out sort of a hierarchical categorization of hate speech. So the first was the gravest forms of hate speech that are excluded from any protection through Article 17, the aforementioned abuse clause. But unfortunately, the court does not specifically define what the gravest form of hate speech is. And then, unsurprisingly, the second is the less grave form of hate speech, which do not fall outside Article 10, but in which the court has considered permissible for the states to restrict. And here the court incorporated not only calls for violence or other criminal acts, but also insults, ridicule, and slander in order to combat, quote, prejudicial speech within the context of permitted restrictions on freedom of expression. So this again, even though the court goes, clarifies that it operates with these two categories, it operates a low threshold for the less grave form of hate speech, which may be restricted by the member states. And I think insults is a good example of this, because what does the court mean by insults, and is it consistent when it says that insults can constitute a form of hate speech? Well, let's take a look at two relatively recent cases regarding Russia. In the Ibragimov and others versus Russia from 2019, in which a Muslim scholar's book was banned due to its allegedly extremist nature, the court found that merely because a remark may be perceived as offensive or insulting by particular individuals or groups does not mean that it constitutes hate speech. So here we see the court warning against adopting a definition of hate speech that is overly broad and therefore may target content that is merely offensive, shocking, or disturbing. But then in the following year, in the Athamanchuk versus Russia, which was an application made by a journalist politician after he was convicted of making statements against non-Russians in which he referred to them as criminals, the court found that, quote, inciting hatred does not necessarily involve an explicit call for an act of violence or other criminal acts. Attacks on persons committed by insulting, holding up to ridicule, or slandering specific groups of the population can be sufficient for the authorities to favor combating xenophobic or otherwise discriminatory speech in the face of freedom of expression exercised in an irresponsible manner. Now, that to me is problematic because it then becomes very difficult to find out whether and in what context insults should be treated as protected speech or not. And arguably, this undermines the court's own requirement on states that restrictions on convention rights must be accessible and foreseeable, and it creates a great confusion. Let me point to some other cases that I think point to the conceptual lack of clarity and unforeseeability when it comes to the court's jurisprudence on hate speech. For instance, the case of Federer versus Belgium, which involved the leader of a far-right nationalist Belgian party who was banned from political office for 10 years for writing and disseminating publications, including statements such as "Stop the Islamization of Belgium" and "Save our people from the risk posed by Islam the Conqueror." Now, here the court found no violation of Article 10, but didn't find the statements were covered by Article 17 and thus fell entirely outside the scope of protection. But it held that the statements were, quote, inevitably of such a nature as to arouse, particularly among the less informed members of the public, feelings of distrust, rejection, or hatred towards foreigners. So here it didn't point to a sort of an imminent danger, but rather it said that this this has a tendency to affect the so-called less informed members of the public. And I think this is one of those cases which tries to target populism, which we heard before, but which may, based on its reasoning, actually and arguably strengthen populism, because it sort of can be interpreted in such a way as to confirm sort of the anti-elitist grievances of populism, of having this human rights court, which says that some members of the public are simply too stupid, ignorant to be allowed to be confronted with certain forms of speech. And this was in fact also highlighted by three dissenting judges who argued that the court's majority viewed humans as nitwits, incapable of replying to arguments and counter-arguments due to the irresistible drive of their irrational emotions. And I think this is actually here something which highlights what I see as a key question throughout the history of free speech, namely that of an egalitarian vision of free speech versus an elitist or more privileged conception of free speech, where the you could say the egalitarian one has roots in Athenian democracy, whereas the elitist one has its roots in Roman republicanism, where you had sort of an elite which had free speech and made public discourse, but not ordinary citizens. And we see this going through the history of free speech again and again, this concern on the parts of those in power of what will happen if you allow the unwashed mob access to share and access information freely. We also see in the Federer case that the European Court of Human Rights says that to recommend solutions to immigration problems by advocating racial discrimination was likely to cause social tension and undermine trust in democratic institutions. And this is, I think, general. There's no attempt on the European Court of Human Rights to establish this link, the danger. So it becomes what Americans call a bad tendency argument. So saying that speech may, down the road at some future point, involve a danger or some potential harm, but there's no requirement that this harm be imminent, which gives more scope for governments to restrict speech. And the court says that again, that when it comes to hate speech, it was not, restrictions of hate speech does not necessarily require the calling of a specific act of violence or another criminal act. Attacks on persons committed through insults, ridicule, or defamation aimed at specific populations suffice for the authorities to give priority to fighting hate speech when confronted by irresponsible use of freedom of expression. We see that formulation again. Another case which I think shows the dangers of the European Court's approach is a case called Nix versus Germany from 2014. Now, this involved a rather quarrelsome German called Hans Burkhard Nix. He published a blog post where he accused a public employment agency of racially discriminating against his mixed-race daughter. So Nix, he accompanied his blog post with a quotation from and a picture of Nazi leader Heinrich Himmler wearing an SS uniform. So there was no question that, Nix, who had a mixed-race daughter, was neither defending nor advocating Nazism, but he was playing sort of the Nazi card to underscore his not so subtle criticism of a local government agency. But under Germany's quite strict laws, where you are not allowed to display totalitarian symbols, he was found guilty of violating this law, and he took his case to the European Court of Human Rights, which found no violation of this freedom of expression, stressing, among other things, that Nix had not explicitly distanced himself from the Nazis and Heinrich Himmler. Now, if you think about it, what the European Court does here is basically to allow Germany's hate speech ban to function a bit like a sedition law. So basically here, because Nix had no intention, he was not a Nazi, he was not arguing for Nazism, he was actually using Nazi symbols to say that someone whose conduct he considered racist was akin to Nazism. This was, of course, hyperbole, but in this specific interpretation, it really becomes a protection of public figures rather than the victims of Nazi crimes, which I think is a rather unfortunate way for hate speech laws to function. But then you can compare these cases with the Vinai versus Hungary case from 2008. This was a case where a Hungarian was was convicted for using for having a T-shirt, I think, with a red star, the symbol of communism, because in Hungary, as in a number of other former communist states, communist symbols were banned. And here the court actually said that it understood that, you know, the communist legacy remains a scar in the mind and heart of Europe, and that you know, it understood why the victims of communism felt unease by the display of this symbol. But then it said it nevertheless considers that such sentiments cannot alone set the limits of freedom of expression. And it said that a legal system which applies restrictions on human rights in order to satisfy the dictates of public feeling, real or imaginary, cannot be regarded as meeting the pressing social needs recognized in a democratic society, since that society must remain reasonable in its judgment. To hold otherwise mean that freedom of speech and opinion is subjected to the heckler's veto. So here, as opposed to a number of the other cases I mentioned, the European Court of Human Rights insists that there must be some real harm, some imminence, you know, related to whatever form of speech is restricted. And I think actually the Vinai reasoning from the court is quite convincing. I also think that banning the display of communist symbols would be an indefensible restriction of free speech. But again, one cannot either deny the totalitarian legacy of communism, and if they are to apply in these kinds of cases, why not other cases? That shows the inconsistency of the convention of the court's case law. We also see such inconsistencies when it comes to the very delicate subject of Holocaust denial, where the court has consistently said that when it comes to revisionism or denial of the Holocaust, that is not protected by the convention, and often it falls entirely outside the convention based on Article 17. Now, and I think, you know, in 99% of the cases, it is probably true that those who engaged in Holocaust denial or revisionism do so as a very thin veneer of anti-Semitism, but then the court in the Perenchik versus Switzerland case, where someone had been convicted for describing the Armenian genocide as an international lie, reached the opposite conclusion. Here, the court said that this was not a permissible restriction on free speech, among other things, because not all European countries agreed that this was a genocide. But the court also highlighted that the determination should be made by historical research, which is by definition controversial and debatable, and does not lend itself to definitive conclusions or objective and absolute truth. But then, when you have this carve out of the Holocaust, that undermines this important jurisprudence from the court, that historical truth is not something that can be legislated. And also, the two dissenting court judges said that the sufferings of an Armenian because of the genocidal policy of the Ottoman Empire are not worth less than those of a Jew under the Nazi genocidal policy, which I think is difficult to argue against. And of course, this also raises the tricky question: what about the crimes of Stalin, for instance? Should it be a crime to deny those crimes, as in fact it is in some countries? Can you really have a consistent application of free speech where you only where you only shield one particular heinous historical crime and not others. So more broadly, what I think is lacking from the court's case law is some aspects in its proportionality assessment, specifically whether restrictions are necessary in a democratic society, whether the reasons for restrictions of hate speech are relevant and sufficient, and whether there's a pressing social need, and also a lack of balancing of competing interests. And I'll set out some of the things that I think are lacking mostly from the court's jurisprudence, and which has led to this inconsistency and lack of convincing definitions. First of all, I think we need to ask a controversial question. So are the historical lessons on which the court's jurisprudence is based, is that convincing? So does too much free speech increase the risk of totalitarian movements, crimes against humanity, or even genocide? And I think, I think having done quite a bit of research on the Weimar Republic, I think this is at the very least a too hasty conclusion, given the fact that Nazis were and Nazi newspapers were actually banned. Hitler was banned from speaking in publicly, and I think not least because the Nazis used the Weimar Constitution to suspend freedom of speech and association when they were in power. So these at least that should bring some balance into this simplified idea that if you allow too much free speech, you increase the danger of a totalitarian takeover. Another example we could point to is Yugoslavia, which, as you all know, was the scene of genocide and crimes against humanity after the Cold War and the breakup. But there in Yugoslavia, as in fact in a number of other communist states, you actually had very strict hate speech laws that sent people to jail for up to 10 years for making hateful statements about the various national and religious groups on the territory of Yugoslavia. Of course, this provision was mostly used to convict those who spoke out and criticized the government. And as I mentioned, in the Soviet Union, you had stringent hate speech laws, which again were used more to penalize dissent. And you could ask the question whether there's ever been a regime guilty of genocide which has ever been committed to free speech. I would very much doubt so. And then on the other hand, when it comes to slavery, to segregation in the South, to European colonialism, and indeed to apartheid, censorship and repression has been absolutely instrumental in the oppression of persecuted groups and minorities. And in fact, some of the laws adopted were sort of prototypes of hate speech laws that protected white South Africans, British colonialists, white slave owners, and so on. So that historical context, I think, should also be acknowledged by the court when it's doing its balancing exercise. So I'm not saying that the court has not been right in allowing restrictions on free speech. I think it's quite clear from the wording of Article 10 that it's not, couched in absolute terms. So restrictions on hate speech are permissible, but they have to be conceptually clearer. Also, as I've already alluded to, we need to address the question of the potential harm in hate speech. What types of harms are we talking about? And how direct does the link between the speech and the harm have to be? So, for instance, if we take the Lilliendale case, it seems questionable whether homophobic online comments by a 74-year-old man in Iceland entails any real danger to the LGBT community in one of the most tolerant countries in Europe. And another thing that is worth, I think, taking into account is that typically members of previously persecuted communities can only hope to be protected against hate speech when they are sufficiently accepted by the majority to adopt such laws, which diminishes the argument that they actually need this specific protection. On the other hand, in countries where, for instance, LGBT communities are under threat, we typically see free speech restrictions being used to protect the majority against offense, and we've seen that in Russia. We've seen that in Poland. We see that in Turkey, and so on. So based on this understanding, you might argue that free speech is more important to vulnerable minorities or is important to vulnerable minorities. Then I think if we assume that there are real harms in free speech, and I accept that free speech can lead to harms, then are free speech restrictions an effective and necessary remedy? Because it does not automatically follow that the harm in hate speech is offset by legal injunctions. Hate speech laws are not this magical remedy that will automatically offset the harms in hate speech. In fact, we might ask if the cure can sometimes be worse than the disease. So, for instance, we have studies that point to increased proliferation of hate speech when prominent politicians like the Dutch far-right leader Geert Wilders was prosecuted. Hate speech proliferated in the Netherlands. And some studies even suggest that right-wing extremist violence is more prevalent in countries that do more to prohibit right-wing extremist propaganda. And of course, it can also provide a platform of martyrdom and confirm populist anti-elitist grievances. So whether you agree with this or not, I think these are at least some factors that the European Court of Human Rights should include in its balancing exercise and accept as counter arguments to the more simplistic reasoning that hate speech should simply be banned. Another thing is the abuse of hate speech law and scope creep. I mentioned the Nix case, but we actually see also memorial laws, so laws criminalizing the denial of certain events being used in Russia, Rwanda, and Ukraine to target dissidents. In India, we see actually British colonial era progenitors of hate speech are used to convict people who dissent against Modi's Hindu nationalist government. So this is an example of how hate speech laws may be abused. And I think, you know, if we look outside the European Convention, some of these concerns have been acknowledged. And I want to ironically here go to the UN system, because even though the ICCPR includes a specific duty to prohibit certain forms of hate speech, it has been interpreted since 2011 and the General Comment 34 and also the Rabat Plan of Action in a much more speech protective manner than the European Court of Human Rights hate speech jurisprudence. So for instance, the Rabat Plan of Action, which I mentioned, includes a 6-part threshold test for applying Article 20 of the ICCPR, which provides that any advocacy of national, racial, or religious hatred that constitutes incitement to discrimination, hostility, or violence shall be prohibited by law. So this includes the social and political context, the status of the speaker, the intent to incite the audience against a target group, the content and form of the speech, the extent of its dissemination, and crucially, the likelihood of harm, including imminence. Now, the first 5 elements are arguably also part, even if not applied consistently, in the European Court's interpretation of free speech versus hate speech. But the likelihood of harm often is lacking, and I think that's a key element if you want to ensure that hate speech provisions do not become overly broad. And we see that the Human Rights Committee under the ICCPR also has adopted a more speech protective interpretation of hate speech, and is much more on the guard and much more suspicious of hate speech laws. For instance, it explicitly prohibits memorial laws. So under ICCPR, you could not Holocaust denial, for instance, even though early on they actually accepted the Holocaust denial laws, that would arguably not be protected, or that would not be permissible, restricting that under Article 19 and 20. And there's a very interesting decision called Rabe versus Netherlands, in which the committee found that the Netherlands had not violated Article 20 when Geert Wilders was acquitted for hate speech against Muslims. And 2 members of the committee issued a concurring opinion in which they stated that hate speech and similar laws, ironically, are often employed to suppress the very minorities they purportedly are designed to protect. Thus, while appropriately tailored laws addressing hate speech and hate crimes have an important role around the world today, abuse of overbroad criminal provisions to suppress speech by journalists, human rights defenders, political opponents, and other social critics is a frequent concern of this committee. So that type of warning against overly broad hate speech provisions is much more at the fore at the UN level by the Human Rights Committee than it is at the European Court of Human Rights, in my opinion. Another very interesting example is South Africa. Very interesting because South Africa has recently emerged from decades of apartheid, and so has grappled with what should be the relationship between free speech and hate speech. But what was characteristic of apartheid was actually that censorship and suppression was a key tool of white supremacy rule. And so they had this censorship board, which, and I'll quote from it, said that the appeal board has emphasized that the South African community in no way wants to suppress criticism against whites or the government, but writers should realize that they are on delicate ground and they have to make sure that what they publish does not assume the character of a hateful attack on the white man. So in essence, in apartheid South Africa, you had something approaching hate speech laws which protected the white minority against the majority, which it oppressed through white supremacy. And interestingly, the South African courts are very mindful of this past when they look at free speech and hate speech cases. So the Constitutional Court, for instance, has held that free speech is the lifeblood of constitutional democracy, and that when citizens are very angry or frustrated, it serves as the virtual exhaust pipe through which even the most venomous of toxicities within may be let out to help them calm down, heal, focus, and move on. So this is very different from for instance, the Federer case, where the European Court of Human Rights says, well, we have to be on the guard because if people say controversial stuff, it may down the road lead to various forms of harms. The Supreme Court of Appeal, explicitly invoking the dangers of apartheid-era censorship, has also held that the fact that political expression may be hurtful of people's feelings or wounding, distasteful, politically inflammatory, or downright offensive does not exclude it from protection. So again, this marks quite a stark contrast to the European Convention when it comes to insults, for instance, where the European Court of Human Rights on numerous occasions have said that insults can qualify as hate speech that can be permissibly restricted under Article 10. And in a very recent case, which is interesting, dealing with homophobic speech, quite comparable to the Liliendahl case from last year from the European Court of Human Rights. The Supreme Court of Appeal overturned a conviction of someone who said derogatory statements about the LGBT community, and it said that the overbreadth of a definition of this law, which permitted restrictions on homophobic speech, which we are here concerned, can scarcely be described as marginal. It is not as if we are confronted merely with a peripheral excess in scope surrounding an identifiable prescriptive core that targets constitutionally unprotected material. Rather, the virtually unlimited range of unconstitutional potential application of the Act overwhelms whatever permissible prescription might be identified. So I would argue, even though that we also see some inconsistencies among various different courts in South Africa, the top courts, the Constitutional Court and the Supreme Courts of Appeal, tend to be very, very critical of hate speech restrictions and really adopt strict scrutiny to both the language of the laws or rules that permit such restrictions and the reasoning behind them, and really attach decisive weight to the countervailing interest of free speech in a manner which I would say is the exception rather than the rule when it comes to the European Court of Human Rights. So in closing, I would say that I think that the European Court of Human Rights does not protect, in essence, ideas that are offensive, shocking, and disturbing when it comes to hate speech. And moreover, its hate speech jurisprudence is inconsistent and lacking in conceptual clarity. And even, you know, and you don't have to, you can still be in favor of hate speech laws, but advocate a much more rigorous, consistent approach to interpreting such hate speech bans by drawing influence from the Human Rights Committee under the ICCPR, as well as jurisdictions like South Africa. So those were my comments. I very much look forward to your hopefully critical questions and comments about this topic. Thank you very much.
Thank you, Jacob, so much for this very detailed analysis of complex issues. Of course, it raises a lot of you know, sub-questions and comments and clarifications. But before we turn to this, we had asked whether you could also probably Natalie could demonstrate the database, the platform, because some of us actually used it and found it very useful. So is it possible for you, Natalie, to actually share your screen and maybe Natalie and show us the platform? Thanks.
Sure. Yeah. So essentially, this is the website of the project, and it's a good one to watch because it's where we have all our publication, upcoming events, any events with recordings like the one today, all go on our website, so you can follow it. The first database we made, the first kind of interactive tool, just to give you a little bit of background, because the project includes a plethora of different activities. One of the things we try to do is also develop tools which are useful for professionals, yeah? And we consider that this is one of the tools which is useful also for academics, for students, for professionals, for policymakers, because it's the only database which brings together all ECHR case law on hate speech, right? And what we've done is we've divided the content. So, for example, LGBTQ, genocide denial, violence, ethnic hatred, and if I go here, if let's say I'm interested to see, for example, cases against the Netherlands or against Turkey or wherever, I can also search the cases by country, or I can search them by theme. And if you see the circles, their size differs according to the number of cases. So we see immediately from looking at the illustration that homophobic, transphobic, biphobic speech are the fewest of the cases. So just to give you a sample, let me find a French case so I can just show you what we've done. So let's go to the case that Jacob mentioned with Mr. Federer. This case, as many of you probably know, is only available in French. And what we've done is all case law, whether in English or in French, we've offered the summary. So let's say I'm interested in reading it, I'll go through it. If I see that, yep, this is relevant for my work or this is relevant for my research, then I can go to the full link. So we've also overcome some linguistic obstacles. We've given important paragraphs from the judgments and whatever else. So yeah, this is our ECHR website, and just a couple of minutes to show you what we've done on a UN level. We've created the same thing with the cases available on a UN level. So from the Committee on the Elimination of All Forms of Racial Discrimination, the Human Rights Committee, and also the CEDAW. And again, it's exactly the same thing. We've divided it according to theme. And we also, exactly the same with the ECHR. What we've done with both the ECHR and the UN is, as well as the case law of the courts and also the former committee, we've also incorporated all the relevant documents of the different Council of Europe bodies. Yeah, and we've done that for the UN as well. And of course, we're on top of the case law development, and any new cases that enter go in to the database. And just a last thing to show you, since we're here, we've developed the handbook, a global handbook on all hate speech laws around the globe. Okay, so this is a huge thing that you can have a look on your own. And essentially, we have the regional levels and the international levels. We have the policies on hate speech on a social media level. And then let's say I want to see what the law is in, I don't know, Romania. Okay, I'll click on there. Has Romania ratified the ICCPR? Yep, we have a ratification. Has Romania incorporated a declaration or a reservation? No. Sorry, Russian Federation. And then we have the Federal Criminal Code, all the relevant documents, relevant to hate speech. So anyone who's interested on what laws exist on a international level, you can also use this tool. Yeah, is that if you have any questions, you can let me know. I'll stop sharing now.
Thank you, Natalie. This is so impressive. And I think it explains some of the methodological questions I had for Jacob. By looking at the platform through your demonstration, it explains a lot of what I had to ask him from a more scientific perspective. But anyhow, it's time now. We have about 25 minutes for discussions, and I'm sure there is a lot to discuss. So Jacob is back. Thank you. And the floor is open. So I'm monitoring the chat. So is Andrea, and so is Andreas anyway. I can see there is one question already in the chat. So maybe I start with these. And then if anyone wants to make an observation, an oral observation, just raise your hands through the, the tool, and we'll give you the floor. You can also write questions in the chat. So there is a question from a guest of ours, who I think works, if I'm not mistaken, at the European Commission, but maybe I'm wrong. The guest says, what are the reasons for the difference between the more freedom of expression friendly interpretation / application of ICCPR Article 20 and hate speech a friendly European Court of Human Rights case law? Thanks. I'm not sure I understood the question. Maybe Jacob did. It's in the chat. So that's the difference between the two approaches.
Yeah. What are the reasons for it, or more differences? Sorry.
That's what are the reasons for the difference in the approach?
Yeah, that's a good question. I think one of the reasons is at the ICCPR level, at the UN level, America has played a role. So it has really tried to have its more First Amendment approach to free speech, which has influenced. But I think there's also more of an awareness, probably at the UN level, that a great number of the member states are not democracies. So at the Council of Europe, you obviously have a number of states who are not liberal democracies. You unfortunately have an increasing number of worrying states going in a worrying direction, but you have and have traditionally had a core of democracies, liberal, stable democracies, where you, from the European Court of Human Rights, might trust that the authorities would not abuse the hate speech bans to target dissidents and minorities and so on, whereas there's been much more skepticism at the UN level. So I think that may help explain this. And also, I think at the European level, the World War II and the Holocaust, the Holocaust background is so prominent, so it plays such a huge role. Whereas at the UN, there are many countries where the Holocaust and the specific events that shaped our understanding in Europe of limits between free speech and hate speech are not necessarily the same. So that may also provide an explanation.
Thank you, Jacob. I think that's clear. I have a couple of questions, but please, students and colleagues or guests, feel free to come forward with questions. If nothing is coming, then I will ask you something myself. No? So, okay, Jacob, I'd like to ask you, I did see through the demonstration with Natalie that you have, a comparison with the EU level as well, and the framework of hate speech at the EU level. I was wondering whether in your work, first of all, you look at instruments such as the EU Charter, which would be another one. And secondly, whether you actually look at case law at national level, not at the ECHR level, but actually national level. I'm thinking about cases like Charlie Hebdo or the likes. So it's a two-tier question.
Sure. Yeah, I think we have identified one ECJ case versus hate speech, but in general, these tend to be decided by the European Court of Human Rights rather than the ECJ. But we do have various EU instruments, so like the framework decision, the code of conduct agreed between the Commission and a number of tech giants, and also the audiovisual directive, I think it is, which also includes hate speech language. But I would say in general, there are more sort of legislative, policy-oriented initiatives at the EU level, which of course have huge implications. Whereas the case law tends to be generated by the European Court of Human Rights. So yeah, of course, the EU level is absolutely crucial, and we look at that also in terms of for instance, the Digital Services Act, which will have a huge impact on content moderation of social media platforms. So that's an important level. It's obviously difficult to follow closely the case law in all European member states. Forget about the Council of Europe, even the European Union. Also, language barriers and so on. But we obviously there can be cases that are really important, not just related to hate speech, but so. For instance, there's a case that I've been following that was recently decided in Poland, where you had a couple of women who had been charged with religious insult for having set up posters of the Black Madonna in rainbow, in LGBT flags, and they were acquitted recently, but they faced up to 2 years in prison and had been charged for a long time. So and obviously, as you mentioned, incidents like Charlie Hebdo are critical. So whenever these cases that are really sort of have a bearing on free speech more generally, we try to follow them, but we can't do it consistently. We simply don't have the resources to do so.
Thank you, Jacob. There is a hand up. I'm sorry if I don't pronounce your name well, but we have Junkal's hand up. So do you want to take the floor?
Hi.
Yes, we can hear you.
Okay. Well, thank you very much for organizing this roundtable. It was very interesting to me. I'm a PhD student at Hasselt University in Belgium, and I'm researching specifically hate speech in social media. So I research content moderation, the Digital Services Act, and I would like to, well, I have a lot of questions, but I would like to ask Jacob about Article 8 of the ECHR and whether you think it can contribute to the court's case law on hate speech, and whether it can contribute kind of making the case law more clear and more consistent. For instance, last month there were 2 Bulgarian cases decided by the court where Article 8 is used, and the case law of the court is developed in actually giving a more clear line to the severity threshold that statements need that hateful statements have to achieve in order to be considered hateful. So I was wondering, yes, about Article 8 in respect of hate speech, because you mostly focus on Article 10. And then I have a question about your database, which I find super useful. Because I saw that you identify basically around 60 cases of hate speech by the ECHR, and I was wondering how did you identify those cases? Because when I look at at the HUDOC database of the court, and I just type hate speech, I get more than 60 cases, and I also know that in some hate speech cases the term hate speech is not there. So I was wondering about that very methodological question. Thank you.
Yeah, well, it's a good question with Article 8. I think in some ways it might actually create more confusion because of the court's interpretation of a positive obligation, basically. So it's one that can be used by victims in the same manner as Article 20 under the ICCPR. So and that to me just makes it even more difficult for states to navigate, because, and you could even say, does that mean that they have to then spend more time surveying problematic expression in public, and then take action themselves. So I don't think, Article 8. There's a lot in Article 8 already. It really has become unmanageable, I think, and I don't necessarily think it helps to create more clarity when it comes to the question of hate speech, unfortunately. In terms of our database, I hope we've explained the methodology, but I think maybe Natalie can is better.
Yeah. Okay, so essentially, with our ECHR database, the difference with the formal, let's say, website that you refer to of the court is that if you insert the term hate speech, two things come up. Firstly, when a decision is originally written in French rather than a translation from English to French, the term discours de haine is not used. So discours de haine is used in the translations of the English of English case law. Yeah. So that's the first reason why we have more in the ECHR database, because this is something that we were fighting with a lot. Why are so many appearing there, and why do we have this number? And the second thing is that in the results that you get when you search, you also have all that bulk of the Turkish case law, which does not necessarily target protected characteristics. Yeah. So what we did is we are this pure notion of hate speech, hate targeted towards hate protected characteristics, so ethnicity, sexuality, and whatever else. That doesn't mean that you won't find Turkish case law in the database. You will, but you will only find the case law which was particularly targeted to characteristics. Does that answer your question?
Yeah.
Yeah, okay.
Thank you, Natalie. That was very helpful. Yes, I mean the logistic of the linguistics, which you explained twice. I mean, this is extremely impressive because obviously, there is a huge difference in the way hate speech is perceived in the French way, and the way it's actually set out is a very different thing. So this is a very important thing to take into consideration, definitely. I know that Andreas had his hand up, but now it's down again. But there is someone else. So Andreas, please. Yes.
If there's no one else, then I can go ahead. Yeah. Well, first of all, Jacob, thank you very much for your talk. I thought it was very, very interesting. I have several questions, but I'll try to keep it brief. First, I have a comment, because at a point you mentioned egalitarian free speech and elitist free speech. And you linked egalitarian free speech to ancient Greece. Of course, that's fine. I mean, in terms of rhetoric, that's fine, because that's how we usually talk about ancient Greece, right? The birth of democracy, free speech, and all that. But in terms of substance, it's clearly more problematic than that, right? So free speech in ancient Greece, or Athens, if we want to take a more democratic part of Greece, was limited to a very, very small portion of the population, excluding women and slaves and all that, and even to male-born heads of households who were considered citizens. Even among those, a very small fraction was able to actually exercise those rights, because they were subject to the same limitations, material limitations, that we have today, right? So citizens in ancient Athens had to work in the fields. If they had to work in the fields, then they couldn't be in the agora and they couldn't talk. So it was only, essentially, at the end of the day, it was aristocrats who were able to exercise free speech, with some exceptions, notable exceptions, like Socrates, for instance, who had no money but was still able to practice free speech. But he was able to do that because he benefited from his disciples and his friends who offered money and food and all that. And crucially, on the same point, Greece, ancient Athens, had robust legislation legislation in terms of blasphemy, right? So there were a lot of things that you couldn't say in ancient Athens. And part of the reason why Socrates was driven to a trial, and part of the reason why he was eventually convicted, was because he talked in ways that undermined conventional wisdom and conventional knowledge in ancient Greece. So those are just simple comments in terms of what actually happened in ancient Greece and how it's quite different from how we might imagine free speech. Now, if I could turn to a very short question. At the very beginning of your talk, you mentioned about how there's no definition of hate speech that we can use. And I was wondering, what are your thoughts on that? Do you think that we need a definition of hate speech? And if there is a need for a definition of hate speech, what kind of assumptions do we have, right? So do we assume that hate speech must be combated, and do we assume that hate speech must be legally must be guarded against, right? And if so, how would that work if we had a definition that would apply in all sorts of different states, and those states have different systems, different legal systems, and crucially, different degrees of democracy, because this is something that you kind of alluded to in later comments when you talked about the harm of hate speech, right? And how countries like Turkey and Russia, which are non-democratic countries, have different attitudes towards hate speech compared to a democratic country. You mentioned the case of Liljendahl, I think, speaking about how in Denmark, was it a case in Denmark, Liljendahl, the case with LGBT? Iceland, yes. And you mentioned that there's a specific culture sympathetic to LGBTQ or not against LGBTQ people, and so that made the harm less severe. So I was wondering if you had any thoughts on that. Thank you.
Thank you. Yeah, no, when I say going to your first comment on the Athenian democracy, it's certainly true that by our standards, it would be difficult to argue that it was egalitarian when you have slaves and you keep women at home. In the same way that you could say before we had social media, we would think that we had egalitarian free speech, but in reality, in the days of analog, it was also an elite who had access to exercise free speech. All of us might be passive recipients of free speech. It would be very difficult for an ordinary person to actually speak, unless they put up a soapbox and had an audience of 20, 50 people. But I would still argue that the Athenian model of free speech was progressive compared to much of what went on for a very long time after that in European history, and certainly much more progressive than the Roman model. And this is what if you look at Cicero, he basically blames the Athenian democracy for the downfall of Greece, and because they allowed licentious speakers and ordinary unwashed mob to at least in theory exercise free speech. So of course it's important to not idealize the model. I agree with you on that. Whether there's is there a need for a European wide robust definition of hate speech? I think one of the problems with defining hate speech, even though I've sort of decried the court for not having adopted one, it is extremely difficult to define hate speech. But it would, one way to do it was perhaps to do, rather than a positive one, then for the court, at least when interpreting hate speech provisions, to have a negative one. What should it not be allowed and I think this is what, for instance, the South African court did. So it said, yes, our constitution explicitly exempts hate speech from the protection of free speech, but it's a very narrow category. So don't come running with laws that prohibit insults and all these things. That could be, that could, if you had sort of more of a negative interpretation applied by the court, then you could, then that would help also filter down at the national level and maybe create more robust national interpretations that could then vary, because obviously we're not going to have the same definitions of hate speech in all member states of the Council of Europe. So I don't know if that makes sense.
Thank you, Jacob. I think it does. Andreas, do you want to add something?
No, thank you. That's exactly what I was asking, right? Because at the end of the day, how different countries treat hate speech and regulate hate speech is dependent on the particular democratic culture that this place might have and the different protections they afford vulnerable minorities.
Yes, I agree. I mean, I had it down as well as a question for Jacob, but I wanted to focus on the regulation of hate speech, which of course the definition is part of. And also this is something we did not really address, but I'm sure it's quite present in your work as well, Jacob and Natalie. It's you spoke a lot about the historical context and how this is of course crucial in how we work, and again we just discussed it now. But what about the background of the judges? Is this something you're looking at when you're actually looking at the case law of the Strasbourg court? You know, who, who are the judges? Is this something you think is of importance?
I think that could be a really interesting research paper, looking at the judge, because as I alluded to, there are some cases which are, a couple of Hungarian cases, for instance, that read almost like, the American Supreme Court on free speech with very, very robust protection. And then you have others where they seem to think that, even insults should be restricted as hate speech. And of course, that can contribute to the lack of clarity and lack of proper definitions. It's not, we'll steal that idea and run with it.
Well, we're happy to support you with this if you need. Happy to work with this. I think, we have reached the end of the roundtable. This is an exceptional roundtable for all of us. So thank you so much. I mean, for us to have the opportunity to be able to have direct access to your work and the platform, I think for the students is obviously of much value. And I'm sure we will actually think about how to integrate this into our work. We welcome anyone on this roundtable, students from Ukraine, Cyprus, but also guests. We have seen some PG students, for example, or some people working in international organizations. Please get in touch with us. We would be happy to, do more work on this from the point of view of populism, but not only. I think Andreas gave a very nice linking at the beginning between, populism, free speech, and hate speech, which is worth exploring. So thank you so much for this. I cannot be more grateful than this. This has been a very nice afternoon. We would like more of those afternoons, basically. Now that Natalie is here, can I take a picture? Because I see that Demetra is here as well.
The pleasure was mine. It's been an absolute privilege. Thank you very much.
Well, thank you very much, Jacob. Thank you very much, Natalie, for putting us in touch, obviously. And we look forward to reading your work and listening to your work, and perhaps also working with you again. Thank you, everyone who attended. We will stop the recording now. People are free to get in touch with us if they would like to know more about the UPOP, or if they want to get in touch with Justitia. I think you know how to do this. Thank you, everyone.